Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline Lawyer. This is another episode in our series entitled Busting Industry Myths. And here is today's myth. Listing brokers should withhold from sellers any love letters presented by a buyer. Love letters, which are those letters from hopeful buyers anticipating a multiple offer scenario. The letters where buyers write about their own situation. Why should the seller pick them as the buyer? Maybe it's based on their race, their ethnicity, their religion, their sexual preference, whatever it may be, their marital status, with or without children. Lots of characteristics about a buyer that if the seller actually did what the buyer proposes by writing that letter, which is pick that buyer because of those characteristics, then seller would be in violation of the Fair Housing Act. That risk is so great, the myth says, that listing brokers should simply withhold those letters from seller. Prevent seller from inadvertently or even intentionally violating the Fair Housing Act by withholding from seller the very fodder that might lead to the violation. If seller never sees the letter, then it can't be true that seller relied on the information in that letter to violate the Fair Housing Act. And so brokers across our state are taught to simply withhold love letters from sellers. The notion that a listing broker actually has the authority to do that is a very dangerous myth. In Washington, you have no ability to do that. There are other states where legal counsel tells brokers to withhold love letters. And presumably in those states, it's lawful. It is not lawful in Washington. Our own Human Rights Commission, Washington's own Human Rights Commission, for a time told brokers you should withhold love letters because delivering them is too dangerous. But the Washington State Human Rights Commission has nothing to do with enforcement of Washington's real estate broker agency law. And what the agency law says is listing brokers, you may not withhold love letters or any other written communication to or from the parties. What the agency law says specifically is every broker has a duty to timely deliver all written offers and other written communications to or from the parties. Broker, you have no authority whatsoever. Even if the seller says in advance, I don't want to see love letters, you still have an agency law, a statutory law duty. And it's an unwaivable duty, meaning that the seller can't waive your duty, even by saying, I don't want to see love letters. You still have an obligation to deliver the love letter. Seller does not have an obligation to read the letter. You can deliver the letter in a sealed envelope and seller can say, I'm not opening the envelope. I'm not reading it. They could even sign across the back and indicate that they didn't open the letter understanding that it contained, or didn't open the envelope understanding that it contains a letter from a buyer explaining why the seller should select their offer. What should seller rely on in determining which buyer they want to choose in a multiple offer situation? The terms of buyer offers and the financial qualifications of buyers. And that's it. So the offer itself and any financial qualification evidence. Whatever's in that love letter, seller shouldn't be considering, but brokers, you have a statutory duty, unwaivable, to deliver the letter to seller. And then if seller chooses not to read the letter, so be it. You keep proof in your firm's transaction folder that it was the seller who chose not to read the love letter after you timely delivered it to the seller. If you want to hear about some more industry myths, visit one of our classes called Busting Industry Myths. If you have more questions, please visit the Legal Hotline Library at WARealtor.org, and you can follow the links there to ask a question if you don't find your answer in the library. Thank you for being a Washington REALTORS member.